see you. So I'll just assume everyone is doing a lot of this and nodding and saying very interesting, because I can, the lights are right here. I feel like I'm on stage. I guess I am. Thank you very much for having me. Thank you, Margaret, for that introduction, and thank you to all of the organizations that put this together, as well as the sponsors. It's really amazing to see this nice cross-section of the creative and cultural industries in one room. I think a lot of the issues that we face together, but sometimes it takes a little adversity to bring us all into the same room, and it's critically important that we keep talking to each other and learning from each other. And I think you'll see as I go through this sort of talk where we have a lot of common threads and where this may lead us going forward. So, no longer business as usual, a copyright form for BC's creative industries. I think we know it's no longer business as usual. I love this picture. This obviously is 2 concerts, about 20 years apart. And the difference in experience when you go to a concert, a live concert these days, is something else. I think it's not even concerts, it's everything we go to, right? The way that people experience content, the way that they deal with it and use it and want to use it is wildly different than maybe it was 20 years ago. Prior to 2004, copyright was really about exclusive rights of copyright owners, usually authors and producers. And it was an exclusive right that belonged to the author, the owner of copyright. In 2004, a case came down called CCH and the Law Society of Upper Canada, where the Supreme Court of Canada introduced this concept of users' rights. This was a new thing. There's an idea that the Copyright Act and copyright in general is a balancing act between the right of the author or the copyright owner to protect his own works and the right of the world to use those works, to consume those works, to copy those works. But it's a constant balancing act. So if the pendulum swings too far to the copyright owner side, then we've got a monopoly that isn't beneficial to society. If it swings too far to the user side, we lose the incentive to create. So copyright has always been about this balancing. Since 2004, really not since 2004, it was happening long before that, but we really have industry disruption. Industry meaning cultural industries generally. There's a lot of things happening, right? I mean, the internet, this is not rocket science. The internet comes along and throws everybody in a tailspin. Napster threw the music industry into an absolute whirlwind. iTunes, Google. Google is certainly one of the forerunners, if not the forerunner, in terms of pushing the boundaries of users' rights and what users are entitled to do and how to use. The cloud creates a whole other layer of copyright issues. Pirate Bay is sort of the best example or the worst example of a peer-to-peer file sharing site that is really, impacting the industry. Pirate Bay has been shut down, at least in parts of the world, maybe not around the whole world. But all of these things are causing a lot of disruption to the industry. For the first time, I think, we have these really interesting but scary new business models. We also have wildly different market players that we didn't have before. We had authors, we had musicians, we had composers, we had filmmakers, and we had producers, we had publishers and record labels. But now we've got these new, really tech companies that are coming up with ideas about how to push this content out, and they're just going. They don't care about the rules, they are going. They've got an idea, they're not going to wait for the law to figure this out, they go. And that causes an enormous disruption in the industry. And what it means is, couple that with the users' rights that come out of CCH, is we have this incredibly strong user power or customer power, consumer power. I call it fan power, because these are people who love this content and they want to get it. And yes, they want to get it for free. Some want to pay. Arguably, some would pay if it was easy to pay. Who knows? There's lots of arguments there, right? But the truth is, the consumers have power that they've never had before. We used to be able to choose how we push the content out. That decision is being taken away from us because we're just going to take it. And for a long time, we think this is bad. We're used to owning copyright in what we do and owning the product that we create. And that's what copyright law is supposed to do. It's supposed to protect that ownership. But now we have these new market players, new business models, determining how the content is going to be consumed. The law is spectacularly slow. It takes years to get a case to court, and millions of dollars, I know. Millions and millions of dollars. We finished a case that I'm going to talk about the Supreme Court last summer. The decision came down that we started in 2004. So, and it cost a lot of money. And that's typical, to go from start of the trial to, or start of the pleadings until the Supreme Court of Canada. Not all cases go to the Supreme Court, but it's phenomenally slow. Legislation change, even slower. So, something to think about. When you think about how long it takes for issues to get dealt with in the courts, or dealt with by our government, my view, and my view has changed over the last little bit, is that the law is normative. And I checked to make sure I was using this word correctly. Some of you may correct me, but I looked it up. That's why you've got me looking it up there. So the idea is that the law will always recognize social norms at the time they're being heard. It's not supposed to. The law is supposed to decide what is fair or what the right decision is based on the facts that were at the time the case was brought. The reality is, any judge hearing a copyright infringement case brought against Google is not going to shut Google down. I don't care how right you are, no judge is going to shut Google down. But my point is that if the law is normative, it's recognizing what is happening today. So the summer of 2012, some of us would say changed everything, others will say it changed nothing. It either recognized what was social norm at the time. It maybe doesn't have the impact that some people say it does. But the truth is, the summer of 2012, the Supreme Court of Canada issued 5 copyright decisions. They were all heard in December of the year prior. 5. In every single one, copyright owners lost. It was a very depressing day. It was a very depressing summer, actually. The same provision of the Copyright Act, fair dealing, for education was a case I was talking about earlier that we brought. It was a result of a tariff filing that Access Copyright had made to the Copyright Board. And it dealt with the K-12 schools and the teachers copying portions of textbooks and other books to hand out to their students. So for years, ministries of education across the country had paid, they were licensed by Access Copyright so they could make copies of different books and hand them out to the kids. Those licenses fell away, we couldn't reach an agreement, so we started a tariff proceeding. The Copyright Board sets a royalty rate for the right to do that. It gets appealed, not by us, by the ministries of education. They lost the Federal Court of Appeal and they appealed again to the Supreme Court. The issue there was whether a little portion of what is handed out to students in the class is fair dealing. At the time, again, we're talking about research, private study, criticism, review, news reporting. The real issue, query whether public education is private study or research or in any event. The issue before the court was whether or not that was fair. So it was a couple of pages per student per year that was at issue. Sounded very innocuous, I think. And the court found it was fair. Said, no, that's fair. The real issue was how the Copyright Board looked at the totality of the copying and what was going on, and so they sent it back to the Copyright Board to make a deduction to the royalty rate. Anyway, those are the 2 decisions coming to the Supreme Court. 2 of 5, all 5 copyright owners lose. Then, also, the summer of 2012 was a rough year. The Copyright Modernization Act receives royal assent. So this is, I think, 3 or 4 attempts at copyright reform that kept dying on the order paper. Years and years and years of the feds trying to reform our copyright law, to catch up to the digital age, to do all sorts of things. And they finally pushed it through, and it received Royal Assent in June 2012. And it came into force November of 2012. So a couple of key points from the new Copyright Act. My view at the time was that I didn't understand why this was important. My mind's changed a little bit on this. The idea behind this exception is that it permits the use of any published work to create a new work. You can freely disseminate the new work for non-commercial purposes, as long as, there's always like a few layers, right? As long as there's no substantial adverse effect, financial or otherwise, on the exploitation of the original work. So, when I first heard about this, all I could think of was Prince suing the mother who had posted her baby dancing to Let's Go Crazy on YouTube. And that to me was, they're using an existing work, right? They're using Let's Go Crazy. She creates a new work because she's videotaped her baby dancing, and there's art and skill in that, and it's fixed, and so she's got copyright protection in this new thing. And because it's a non-commercial use for private, well, not really private purposes, it's non-commercial use. That's what this exception is meant to capture, and I thought, who cares? I don't need to see the baby dancing to Let's Go Crazy. I didn't think I did. And then I saw this. Any Breaking Bad fans here?
Good girl, I know you want it. You know I want it, baby. Oh yes I do. But you're a good girl, yes you are. Lord have mercy, Lord have mercy. I'm talking about the good life. Yes I am. I know you want it. I know you want it, baby. So come on. But you're a good girl, yes you are. I said I'm talking about it. I'm talking about the good life.
There's lots of problems with the YouTube exception. The way it's worded, it has the potential to be much bigger than what we just saw. The first thing that comes to mind is that a lot of record labels and I think independent musicians were entering into licensing deals with YouTube for the use of their works on YouTube. And when an exception like this is in place, those licensing deals fall away. They're not needed anymore, at least in Canada. The other problem, sort of immediate problem with the YouTube exception is not just about YouTube. There's a thought that it could be used to, for example, take existing books or existing anthologies and take pieces of those anthologies, put them together into a new anthology and use it for educational purposes. It's non-commercial, maybe. Someday I'll probably argue that education is commercial, but today I'll say in theory it's non-commercial. And it's tough to prove that it has a substantial adverse effect on the exploitation of the original work. So, we'll see where this exception goes. I think it will be tested. The TPM and rights management information provision is meant to protect copyright owners, so it's meant to strengthen copyright owners. I'm going to pull out the backgrounder again. So, it is now illegal, or it is a copyright infringement, to circumvent or hack digital locks, like password protections, to gain access to copyright material. It's also an infringement of copyright if you manufacture or distribute services that are intended to break those types of locks. I know nobody here does that, so I'm not worried about that for you. At the time this was introduced, the feds recognized that certain protections are important tools for copyright owners and that they were using these digital locks to protect their online or digital content and some of their business models. So the feds were convinced, I think, by Hollywood and some of the bigger record labels that this was important. Something that not everyone appreciates, the nuance in this really long, it looks like this, and it's pages of this. It's ugly. But it's only really about access control locks. Technically, I think they're the same thing, but they've split up access control locks and copy control locks. So it's an infringement of copyright to break an access control lock. So you cannot gain access to a work by breaking a lock. There's also a limitation on the damages you can obtain against an individual who has broken an access control lock. You're not entitled to statutory damages. You have to prove actual damages against that one individual, so a little bit tougher. The purpose of this provision is really to go after the kind of commercial infringers, the peer-to-peer file sharing sites, those people who break locks and gain access and do it on a widespread commercial scale. It's never an infringement of copyright to break a copy control lock. So old school, I had a Ben Harper CD that I could only copy 5 times. And I was putting on different machines, honest. I don't do that. I'm not handing it out to my friends. But I could only do that on 5 different machines. It drove me crazy. Now, those have kind of gone by the wayside. But you are entitled, I should say this, it's not an infringement of copyright to break those copy control locks. But there are certain other exceptions. You can't take advantage if you break a copy control lock. I know. So the Act has format shifting, time shifting, and backup copies are now exceptions. So we can now all format shift, we can time shift. Used to be infringement of copyright, as long as we don't break a lock to do that. So if the copyright owner wants to prevent you from format shifting, slap on a digital lock, however those smart 22-year-old people do it. You cannot format shift, time shift with that stuff. It's incredibly complicated. That's how it goes. And then fair dealing, the feds expanded it. So I talked about research, private study, criticism, and news reporting as the 5 purposes for which you could trigger fair dealing. The feds added parody, satire, and education. There seems to be absolutely no concern with parody and satire, unless I'm missing something. Everyone, I would say almost everyone, thinks that to create a parody or a satire of original work, you in some way, shape, or form need to copy a substantial part of the original work. Otherwise, no one would ever know what you're parodying. Education has been a much more controversial addition. It's causing a lot of hell in, obviously, the educational publishers world. It's being used to stop a lot of royalty payments to publishers and authors when their works are used in the K-12 schools, as well as the ministries of education, as well as the POSEC. And I think on top of that, it has the potential to creep even wider because, this is education. What isn't education? Every time you get a bunch of people together and talk, well, maybe it's not education, but it's arguably education. So there's no kind of limits on, it has to be non-commercial education, not that that would make it right, but there's no limits there. The only limitation is fairness. And so education is a purpose. The use also has to be fair, and in the new Copyright Act, a lot more exceptions, really broad exceptions. And this idea, that's a really old school idea that copyright owners have exclusive control over their works, over their rights, is really being thrown into disarray. So what? So it's no longer business as usual. It's no longer law as usual. What do? The law is normative, so it plays catch up to societal norms. We might want to start thinking a little more openly about these new ideas or these new business models and these new market players that are coming in. Just a thought. I'm not saying they're right. They're not right. I mean, in a lot of cases, they're legally, what they're doing is copyright infringement. But, okay. My point is simply, we used to fight, and fight against this, and fight against all these things that are happening. Last year, we were told, guess what? It's happened, deal with it, or we're going to create an exception. Or the cases that have worked their way through the courts over the last 10 years are going to recognize what society is doing. So some of these ideas are incredibly exciting and novel, and they're coming from people we never would have thought they would have come from. You know, Google is awesome. It's awesome. They're bad. They're awesome. So just, you know, think about that. It's no longer business as usual. Think about partnering. Think about what you can do. You guys are the creative ones, right? This room is full of creativity and ideas. So think about that. And if you disagree with the way your content's being used, you know, speak up, speak out, say it as often and as loudly as you can to people who listen, to people who don't listen. Publish it. Get it in every newspaper, get it online, do whatever you can. Make yourself, your views known. Because the law is normative. And if we just let these things happen and hope that 10 years from now the court will sort it out and will rewind the clock, I don't think it's going to happen. I hope some of it will get rewound. But given the way it's progressed so far, I don't think we should wait for the courts to fix this for us. Thank you.